Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. One of my very good friends and subscribers here asked me to explain the writ of habeas corpus. So let's get into that. Habeas corpus is a Latin phrase that means literally produce the body. Habeas, produce, corpus, the body. And basically what it tells when it's issued by a court, it tells a public official, you need to bring before me the person that is incarcerated or detained and show me that you have a valid lawful reason to incarcerate or detain that individual. Now, although it says produce the body, that doesn't mean that the body gets produced to the court. It means that that's where the determination about whether the body will be released or produced outside of the prison or jail or wherever the person is detained, it means that's going to happen after a hearing in front of the court. So the way it works, somebody files a petition for a writ of habeas corpus, and the court either issues a preliminary writ or it does not. If it denies the writ, then that matter is done. Now, as a practical matter, courts require that it be filed in the lowest possible court first. So, for example, in the case we're going to talk about a fellow by the name of Travis Jonas, Travis was detained or basically imprisoned at the Moberly Correctional Institute in Missouri. And so in the circuit court for that county, he filed his first petition for a writ of habeas corpus, and the circuit court denied it. So what happened after the circuit court denied it was that it went up to the Western District Court of Appeals in Missouri, and the Western District Court of Appeals said, no thank you. And then, as protocol required, he filed a writ with the Missouri Supreme Court. And the Missouri Supreme Court wasn't quite so fast to say no. They issued a request to have the matter briefed, and it was briefed in front of the Missouri Supreme Court. And this is a little bit about how the jurisdiction in these cases works. And this is what the Missouri Supreme Court said about its jurisdiction and standard of review. It said we have the jurisdiction to issue original remedial writs, and the habeas corpus is an original remedial writ. Any person restrained of liberty within this state may petition for a writ of habeas corpus to inquire into the cause of such restraint. That's directly from the Missouri Constitution, and it is buttressed by Rule 91.01. And the statute, which says every person committed, detained, confined, or restrained of his liberty within this state for any criminal or supposed criminal matter, or under any pretense whatsoever, may prosecute a writ of habeas corpus as herein provided to inquire into the cause of such confinement or restraint. A habeas corpus proceeding may be used to challenge a probation revocation, and that's a case from 2002. Now, Travis Jonas was convicted of identity theft in 2012, and he was sentenced to 7 years in prison. And then, in a remarkable display of judicial mercy, that sentence was suspended, meaning he did not have to go to prison. Instead, he was released back into the community on supervised probation. So when somebody is on supervised probation, they have to make regular visits to the probation officer, and the probation officer can make regular visits to them and come see them at their work, come see them at their house. He can walk in and say, all right, I'm going to tear this place apart and make sure you don't have a gun in here somewhere. All of this is completely legal because that's part of what probation is and supervision is you have to be able to check and make sure the person is following the law. So in addition to getting this 7-year sentence with 5 years of probation, the other part of the sentence suspended, in addition to getting that, he also had an order for restitution and an order to go through something called REACT, which essentially is a assessment program for people who have substance abuse problems. Now, substance abuse apparently didn't play any role in his conviction, and he didn't appear to have a drug problem, and he never had a hot urine screen or a hot drug screen while he was on probation. And so over the course of the 5 years actually closer to 3 years that he was on probation, he never had a REACT assessment, and he was a little bit tardy in paying the restitution. So finally in November of 2015, he pays off his restitution. And in paying off the restitution, that should have been the last thing that he needed to do before his earned compliance credits, what the court calls ECCs, would allow him to escape probation. He could get off of probation and be completely discharged, not have a probation officer, not be subject to constant visits from the probation officer. So he likely did not believe that he was off probation because he continued to get visits from the probation officer. But be that as it may, apparently this desire and this push by the state to have him pay the restitution, apparently that push to have the restitution paid caused him to write a bad check. And when he wrote the bad check, he was arrested, and they did a probation revocation hearing. And based on the failure to attend the REACT or get the assessment that he was supposed to get for substance abuse, as well as the subsequent arrest, and bear in mind, an arrest is not a conviction. Based on that, the court revoked his probation and sent him to prison for 7 years. Now, that seems a little bit heavy-handed, perhaps, but that's what happened. So, when he was arrested, he had a probation revocation hearing, and he probably was represented by the public defender's office. It isn't clear from the record whether he was or wasn't. But once he was out and in the prison, that's a stupid way to say that. Once he was finished with the revocation and he was sent to prison, he filed a motion called a 24.035 motion. That's the number of the rule that governs post-conviction relief. And basically what he did is he challenged the legality of his detention because of his earned compliance credits. And the circuit court said, well, I'm not able to take up the earned compliance credits on a post-conviction relief matter. So this has some impact later on when we get to the dissent in the Supreme Court. But for right now, what happened procedurally is he filed it in the circuit court, the petition for habeas relief, then in the Court of Appeals, and then in the Supreme Court. And the Supreme Court took a look at the situation, and it looked specifically at these earned compliance credits. Now, earned compliance credits are very similar to good time credit that is earned in prison for being a good boy, keeping your nose clean, and not ticking off the guards. This is more of a good time credit for not making the probation officer work so hard. And so he had plenty of these credits, and he should have been discharged from probation, and that is what the Supreme Court found. The state said, no, well, wait a minute. You can't take this up on a habeas petition because he could have brought this up at the revocation hearing. And indeed, he probably could have brought it up at the revocation hearing if he had been supplied with the good time credits as he should have been. But that information wasn't forwarded to the court, and the court didn't have any way to calculate those earned time credits at the revocation hearing. So as a result, the Missouri Supreme Court said, you know what? You're absolutely right. And here is what they wrote. Travis Jonas seeks a writ of habeas corpus on the ground that his due process rights were violated as a result of the circuit court revoking his probation and ordering his sentence executed, despite having sufficient earned compliance credits and having paid restitution in full. He asserts he should have been discharged from probation. Because the combination of Jonas's time served on probation and accrued ECCs would have entitled him to discharge under Section 217.703.7, The circuit court no longer had authority to revoke his probation after he paid restitution. He should have been discharged before the state attempted to revoke probation, and the circuit court subsequently suspended and revoked his probation. Habeas relief granted. Jonas is to be discharged from the Missouri Department of Corrections. So one of the Supreme Court judges, who had been a circuit judge prior to being elevated to the Supreme Court, wrote a dissent where he essentially said, look, you're putting way too much work on these circuit judges, making them get things right. You know, asking them to calculate these credits when it's kind of confusing, that shouldn't be their job. Although the dissent does a fairly good job of talking about, you know, the fact that in the revocation hearing he could have raised this claim, which he didn't know he had. It fails primarily because it starts off sort of complaining about what a hard job it is to be a circuit judge. And if you don't want to be a circuit judge, just don't be a circuit judge. That's the way I look at it. If you're a circuit judge, you have an obligation to treat everybody the same and everybody fairly and follow the statutes explicitly. And they didn't do that. So the writ of habeas corpus was granted, and he was discharged from the Moberly Correctional Institute. But remember that arrest that he had? Well, he'd written a bad check for more than $500. He pleaded guilty to that, and in 2018, 2 years after all of this had gone on, he was resentenced to, I believe it was 3 years in prison, and he was sentenced, that was suspended, and he was given 5 years of probation. So he's back on probation again, and who knows what will happen this time. But hopefully this time he'll pay attention to his earned compliance credits. So that is essentially how a writ of habeas corpus operates in Missouri. There is also a writ of habeas corpus that you can file in the federal courts. But the problem with the writ of habeas corpus in the federal courts is that Congress has very narrowly circumscribed the court's jurisdiction on habeas corpus. They've said you can't use habeas corpus again and again and again and again to try and delay a death penalty. And that's essentially what people often use the habeas corpus relief for. They use it once all their appeals are exhausted, and once the court has issued a death warrant, which is essentially an order. In Missouri, it would be an order from the Supreme Court to the prison at Potosi, Missouri, saying, you know, John Doe here needs to go get the Dr. Kevorkian cocktail and pass on to the next life. Well, at that point, once the death warrant is issued, then a lot of times people will file for a stay of the warrant, and then they'll file a writ of habeas corpus, and they'll allege all of the things they've alleged previously, which can't be litigated, along with some claim of new evidence or change in law or any number of other things. So that's how the writ of habeas corpus works. And in the federal courts, that is very narrow. If it's been raised on a direct appeal, it cannot be raised on a habeas corpus issue. And of course, once you get into the federal system, you file this writ of habeas corpus, and if it's denied, you can ask for a certificate of appealability, and if the circuit judge, or the district court judge believes it should be appealed, he can say, yes, you can appeal this. And if he doesn't, he denies the certificate of appealability. And then they ask the circuit court for a certificate of appealability. And if the certificate of appealability is not granted by the circuit court, then they can file a writ of certiorari to the Supreme Court, where it will be usually at least 6 to 8 months before that gets heard. So it's a very effective way to let someone stay above the grass for a year or so, even after a death warrant is issued by a state. And again, that's one of the reasons why Congress so narrowly circumscribed the jurisdiction of the district courts and the appellate courts, is because they were tired of people who get sentenced in 2000 not getting executed until 2022. Because it's not an effective deterrent if you get to live for 20 years after you're convicted. In the 1940s and 50s, when someone was convicted of a crime, their appeal was handled in a matter of months, and their execution was usually carried out within days of the appeal being denied. A lot of times the appeal would be denied and the death warrant would be issued the same day. So that's where we're at. Hopefully that's a good explanation of the writ of habeas corpus for you. If you have any questions, leave them in the comments down below and I'll try and get to them. We always ask you to like, share, subscribe, do all that stuff. If you found this useful and helpful, please do that. And if you didn't, well, I hope you like the next video. So thank you again for watching. I hope you had a marvelous Thanksgiving, and I'll see you on here next time.